Welcome to today's program titled The Wage and Hour Landscape, an Evolution of Law, Litigation, and Government Enforcement in a Trump Administration World. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the program by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, a CLE attendance verification code will be read later in the presentation. Please write this code down as it will not be reread and is required on the CLE credit request form. During the presentation, you will see a slide with a QR code that you may scan to access and submit your request for CLE credit. You can also find a link to the form in the connection details email you received this morning. Copies of the webinar recording and materials will be distributed to all attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. This presentation has been prepared by Seyfarth Shaw LLP for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I would like to turn it over to our first speaker for today's program, Leon Rodriguez. Leon, please go ahead.
All right, thank you, Donna. Good afternoon, everybody, and welcome to our next in our series of Policy Matters webinars entitled The Wage and Hour Landscape, part of Seyfarth Shaw's expert effort to keep you all up to the minute on developments in the new Trump administration, in this case in the wage and hour area where law, litigation, and government enforcement are constant presences in that area. As I said, my name is Leon Rodriguez. I'm a partner in Seyfarth's Washington, D.C. office. I am also the chair of the firm's government relations policy group, and I will be serving as your moderator today. I have the pleasure of being joined by two people who actually know what they're talking about. They are my colleagues, my Atlanta-based colleagues, Brett Bartlett, who is a partner in Atlanta, and Ariel Fenster, an associate in Atlanta. And I'll ask Brett to introduce himself first, and then Ariel right after that.
Thanks, Leon. Hi, everyone. It's a pleasure to be here with you today. I, as Leon says, sit in Atlanta, which explains part of my accent. I'll try to keep it tame today. But I co-chair our National Wage and Hour Litigation Practice Group. I've been doing wage and hour law for, 24 years, something like that, and have probably defended well over 300 complex class and collective actions across the country and across industries and issues. But I've spent at least as much time trying to help employers avoid those lawsuits and investigations in the first place. And so I'm very happy to be talking to you today. I think this is really important stuff that we're talking about, very uncertain times. But I have the pleasure as well of working right down the hallway from our colleague Ariel. So Ariel, I'll turn it over to you to introduce yourself.
Thanks, Brett. Thanks, Leon. Hi, everyone. I'm Ariel Fenster. I work with Brett and Leon, as they mentioned, and have the pleasure of sitting down the hall from Brett. My practice primarily consists of wage hour counseling compliance work, so answering many of our clients' day-to-day wage hour questions, both from a federal perspective, but also 50-state perspective. I handle a lot of wage and hour and pay practice audits and assessments, as well as Department of Labor investigations. So have a on the grounds understanding of what might be going on a little bit from that perspective, from a government enforcement perspective, and then also advise a lot of our clients during due diligence on wage hour flags or concerns that may pop up as well. So look forward to speaking with you all about this very important topic.
Now, those of you who paid close attention to our invitation materials will have noticed that we were also supposed to be joined today by our esteemed former colleague, Honore Hishamunda, who is now an in-house labor and employment lawyer at LG Chemical. Unfortunately, he had a uncontrollable last-minute conflict arise and is not able to join us today. However, we will do our best to channel the in-house perspective. We always do try on these webinars to invite both government officials who may have different perspectives on the subject matter we're discussing, and also, of course, to include, as we were trying to do with Honore, the in-house perspective. So let's see what's on our agenda today. Next slide. We will, of course, be endeavoring to look at the larger trends in FLSA and wage and hour and current affairs in that area. We'll be looking at what's happening in the agency. You've heard the expression, personnel is policy. I'm a huge believer in that. One key issue there is to understand who is the personnel that matters. And it's not always who it appears to be. And so we're going to try to analyze where the vectors of power, where the vectors of authority, where the vectors of influence are in deciding how exactly this administration is going to be affecting the wage and hour landscape. We'll also be looking at the bigger picture in terms of what might be happening on Capitol Hill, what might be happening in state legislatures in regulation, and not to mention the ever-present plaintiffs bar, which certainly plays no small role in what happens in this area as well. We'll be looking at larger trends to watch, and then the whole point of being here, what to do about all of this. And one thing I'll say at this point is I anticipate that we will be identifying as many questions as providing you information. We are in an area of some great uncertainty. And so we're going to identify the open issues. We're going to commit to you to gather this group back up once again, once we start getting some certainty on what's going to be happening out there. But we will be giving you, again, both questions and answers today. So let's perhaps look a little bit at the ways in which this new administration can be expected to govern, how it's governed so far, how it's governed in the past, and what we can expect in the future. If we are to speak in reality, I think it's fair to say that on the whole, the Trump campaign did not directly take on wage and hour issues. Campaigns rarely do. This is not necessarily an issue that is necessarily commands a broad, as important as it may be to those of us on this call, does not necessarily command a broad political constituency. On the other hand, though, there were a couple of themes that came up that, from my perspective, were really tax issues rather than wage and hour issues, but what I would describe as wage and hour adjacent tax themes. Probably the most prominent of those themes was the proposal, which actually was made by both parties, was the proposal to no longer tax tipped worker tips. This is something that, as all of us around here started thinking about it, has a lot of potential to foundationally affect the employer-employee relationship in those cases, foundationally alter the incentives to either work or not work overtime, or to pay for overtime. And also foundationally can affect the way wages will be structured in certain industries. So while it may start off as a tax proposal, in fact, it ends up having ripples well beyond the immediate proposal. As this administration has begun to govern, it's governing in a way somewhat similar to the way that it did in the first Trump administration. They have started out with a flurry of executive orders. They have not, for the most part, touched that directly on wage and hour issues. But there are a number of issues that come up that do potentially have an impact. One that I would point out is the increased emphasis on immigration enforcement, which is actually my primary practice area, will change the incentives for bringing wage and hour complaints, something that I'm going to talk about later. But it does, these executive orders do point to a style of governance that is unique. And that is one where the White House, personified by the president, drives policy very visibly and aggressively in a way that, again, is unique to this administration. And the results of those executive orders then flow down throughout the administration, manifested in both regulation and sub-regulatory actions being taken in various agencies, including the Department of Labor itself. Now, how this is all going to play out, this remains to be seen. Big priorities until now have been DEI, immigration, various social issues. But this is an issue that undoubtedly will come to the fore at some point. Another unique political dynamic in this administration is the fact that we have both houses of Congress being of the same party as the president, being generally fairly deferential to the president. That has resulted in the so-called Set in Stone initiative, in which legislation is being contemplated that basically would have the effect of legislatively codifying anything the president does, whether it is an executive order, whether it is guidance coming out of certain guidance coming out of executive branch agencies. These will be memorialized, codified, and therefore solidified in a way that is different than an executive order as law. And then looking at it from the other side, the courts, and this has already been demonstrated again in areas other than wage and hour, the courts are going to be playing a critical role as litigation has already proliferated in response to a lot of the actions being taken by the new administration. There have already been some number of injunctions of certain actions being taken by the new administration. And we can expect that to eventually extend as this administration begins to put its own imprimatur on the wage and hour landscape that's similar in this area. Similarly, litigation will itself be an important force in shaping the future of what the administration will do. I want to kind of ask my colleagues here for their questions. What are the things that we're wondering about before we start talking about the things that we know about? Maybe Brett, you first.
Yeah, I'm happy to go. And you know, we are in uncertain times, and we'll be talking about one of the topics that I'm about to raise in just a few minutes. But I kind of wish that I could use the polling function on this presentation. I didn't think about it until too late. But one of the things that we've just noticed, and I've got several wage and hour division of the United States Department of Labor investigations ongoing at present, and they were all dormant towards the end of last year and as we kind of rolled into the new administration. And I was thinking that, that's interesting. Maybe we're going to see a reduction in activity at the government level, and we'll talk about why that might be or might not be in a minute. But then yesterday, well, over the past 2 days, I've heard from 3 investigators saying essentially, hey, we had stuff that we were looking to do and we need to get it done. And it feels like more than just a coincidence. It feels like there was almost a presentation to the wage hour division. Hey, go out and get off your tails and get some stuff moving. So what I would be polling the crowd for right now is anyone else seeing that? If you think of it and you want to shoot me an email or kibitz about this kind of thing, I'd be curious to know if it's just it just happens to be several of the investigations I'm handling and people want to talk to me because they missed me. But that's kind of my question. Ariel, I don't know if you have a question, not to put you on the spot.
Yeah, well, I was just going to add on to what you said, which is, and we didn't talk about this before the presentation. So it's interesting that you say that, because I also had several investigations that were dormant, which I just kind of assumed were a result of the election results. And perhaps the investigators felt like, maybe I don't have to work so hard, or if you don't care as much, or maybe let's see what happens. But I also, Brett, have had several investigators reach out this week and last week saying, hey, I never scheduled those interviews, or I need to close out my investigation. So perhaps, as you know, there was a presentation, because that also has happened to me this week. So
entirely
that
different
can't
parts
be merely a coincidence.
Yeah, entirely different parts of the country too. So it's really interesting. So Leon, I mean, lots and lots of questions, but those are the ones that I thought of and that Ariel thought of.
Yeah, and you know, I would sort of add in that for me, you know, the big question here, and there have already been surprises from the administration along these lines, is just what's personnel going to look like? Who's going to be in charge of the wage and hour division? Who are going to play senior roles in the Department of Labor? You know, these are also things not fully known that I think are going to determine the directions going forward. So, Brett, I'm going to turn over to you now and sort of take us through the big picture of where we are with the FLSA, some of the litigation trends, even some that were preceding Inauguration Day that are going to be setting the course for what we can expect to be seeing in the months and years to come.
Yeah, thanks, Leon. If you go to the next slide, Donna. So, you know, I think we all are generally aware of the current affairs that are affecting the wage hour world, as well as the rest of the world, because, you know, we've all heard of DOGE. You know, are they out there impacting investigators, other members of the wage hour division of the DOL, states and localities? You know, last time around with the Trump administration won, we saw an active push at the local levels, including states, to legislate or regulate around some of the changes that were being made at the federal level, particularly in the blue states. We've got an active plaintiffs bar. We've got active judges who are willing to step into things. And so we'll talk about all of that in just a little bit, but it's a topsy-turvy world right now, and which is why we're here. But if you go to the next slide, please. I thought it might be interesting to level set. So we track every day all FLSA cases that are filed. And then at the end of the year, we try to look and see where the most activity is of FLSA filings. These could be individual cases. They could be collective actions. They could be multi-plaintiff cases. And if you'll recall back in the day, for anyone who's been around for a while, the trend of wage hour filings really began in California. Even though the FLSA had been around since 1938, it started in California in the late 2000s. And then as one now Georgia Tech analytics professor who looks at big data and stuff proposes, there was a lawyer down in Florida who many of you have probably heard of, named Greg Shavitz, who was a personal injury lawyer at the time in the early 2000s and thought that he ought to see about this FLSA area of law, started filing suits. Florida became the most active place to see wage and hour cases under the FLSA filed. But more recently, New York has eclipsed that, and you see kind of the dark orange for the most filings, the lighter orange or the mid-level orange for the mid-level filings, and then the rest of the country. I've got lots of thoughts about what's going on in those other states outside of the big ones, and we'll touch on that just a little bit. But if you go to the next slide, please. So we look at trends across the years, and we've been going back, I don't know, since about 2004, 2005, looking at the number of FLSA filings per year. And it is interesting to me, I think, that we've seen a downward trend, especially since 2020 with COVID. And I would argue that the reason we started seeing a downward trend then was because the courts kind of slowed down. Some of them closed. We saw the plaintiffs bar, slow down, not file cases. And it's just been a little bit of a slow building again of cases filed under the FLSA. But one of the things that we've observed over time is that the number of case filings can be impacted, or at least correlatively so, by the economy, by the plaintiff's bar trends, what they're looking at, what they're doing. And if you go to the next slide, I almost put on this slide Brett's theory, because I'm not going to suggest that I've done any kind of true deep study of this. But one thing I always say about labor employment lawyers is we're kind of omni-cyclical. If the economy's good, we've got work. If the economy's bad, we've got work, because there are always employees and employers who need to understand how to respond to their needs. But I really do think that during good times, we generally see a lower incidence of wage hour claims being filed. And that's in part because employees feel stable, they feel comfortable, they don't want to rock the boat and lose their job. And then on the other side of things, when times are uncertain or when they're really, really bad, but not quite rock bottom, we see kind of a mixed bag of case filings year over year. And I think that that goes back to this sentiment that if it's a really bad economy, I don't want to lose my job. And, you know, none of our clients, of course, would ever fire someone for bringing an FLSA claim. But still, that psychology of the moment is such that I think that employees who are in difficult times don't want to file suit or bring a claim because they're afraid they might lose their jobs. When the economy hits rock bottom, that's when we see a spike again. And if you went back and you looked at like 2008, 2009, you'd see an upward swing in the number of cases filed. I don't know yet, but I think that we're probably going to see an upward tick in cases filed in 2025 relative to the prior years. And so that's just, you can call it Brett's theory, and then you can call me up and tell me I'm completely wrong and all wet, but that's one thing that I think about. And so if you go to the next slide, please.
I think you're on mute, Brett. Okay. I think this is my portion. So I want to talk a little bit about what we can expect at the Department of Labor, what we know so far, and just as importantly, what we don't know. Next slide. We do have a new Secretary of Labor. Her name is Lori Chavez DeRemer. She's formerly a congresswoman from Oregon. She is not exactly the kind of Secretary of Labor that we saw in the first Trump administration, and not exactly what we would expect, colloquially anyway, in a Republican administration. She is a member of the Republican Party. However, she has taken a typically pro-union, pro-employee positions, particularly when compared to other Republican members of Congress. Most notably, she co-sponsored and supported the PRO Act initially. She did back off from that. These things happen in confirmation hearings. She and has been a little bit harder to pin down. And it's not completely out of the realm of possibility that either she decided or her prep team decided that it would be wise for her to at least ease up on her pro-union stance. But this is not out of line with the fact that the Teamsters did support President Trump. So it doesn't, it sort of challenges the idea that the Democratic Party has some hegemony over union political support, and they of course supported her nomination. And this is, as we think about it, not completely out of keeping what is always sort of an underlying theme, I think, of the Trump campaign and the Trump presidency, which is support for working persons, albeit in a way different than sort of the traditional labor union centered views of what that means. There were businesses that opposed the Secretary Chavez DeRemer. She was confirmed just a few days ago with several Democrats voting in her favor and Republican voting against her. All of this means we don't really know what she's going to do. And this is the place where personnel being policy, that notion becomes really important. We don't know what agenda, what her priorities are. We don't know what her particular agendas will be, and we don't know how much of that is going to come from other places in the federal government. So we don't know the degree to which the White House itself is going to drive policy. Presumably on union issues, she'll have a very clear and defined voice, but there may be many other issues on which she will not necessarily be as defined a stamp. So one of the big questions is going to remains, in addition to Secretary Chavez DeRemer, who are really the key points of power within the administration. And then the big thing we don't know here is who is going to be the wage and hour administrator. This is a position that is perennially occupied by acting administrators. This is an area that is, for both parties, frequently challenging for confirmation. And so this leads to one of these open questions that we're not necessarily in a position to answer today. Maybe we can go over to the next slide. As we said, her record on wage and hour is slim, so we don't know where she'll end up on this.
And Leon, I hate to steal your thunder on some of this stuff, but some of these things on this slide are areas that I get really excited about. And so if I can just touch on a few of those, we don't know where the Department of Labor is going to go on the wage and hour divisions, FLSA, executive, administrative, and professional exemption salary level test. I think everybody probably has paid a lot more attention to this quirky issue than many quirky issues out there in the FLSA. But as you probably are aware, back in July, the rules under the last administration would have taken the salary level test up a little bit, not totally unmanageable. And most employers who had employees who were being treated as classified as exempt and being paid at a level that was beneath this $844 per week that it would have gone to, went ahead and made that change. And then everyone was getting ready to the extent that they had employees who were paid lower than that next level that would have gone into effect January 1, 2025, taking it up to over $1,000 per week. Everyone was kind of getting ready for that. And then a Texas federal district court said, I'm going to stop that rule. It's not valid rulemaking, et cetera, et cetera. It sounds just like what happened back in 2016-ish. And in the old Obama administration with their rulemaking around the same issue. And then the Trump administration came in and put a stop to that rulemaking. Same thing happened this time. A really interesting thing just happened, I think. And that is that the Department of Labor, even days after President Trump was inaugurated, went ahead and appealed that ruling to the Fifth Circuit Court of Appeals. So that question is before the Fifth Circuit right now, whether that rulemaking was valid and whether these new salary levels go into effect. And so it's yet to be seen if the new Secretary of Labor will cause that appeal to be withdrawn or what happens. Same type thing with independent contractors. There's a lot of litigation over the independent contractor rule that's going on. It's stalled out right now by several courts, but it's still being fought about. We might see the joint employer rule. And I was just going to touch on the fact that Keith Sunderling has been confirmed as the Deputy Solicitor of Labor. He was an acting administrator for the Wage Hour Division previously, and I just call him out because when he was an EEOC commissioner, he was fascinated and really invested in artificial intelligence and its use for efficiency purposes. And we've thought for a while that at Wage Hour, we might actually see a move to make enforcement more equitable and more efficient by using AI to select businesses, employers out there who might need to be investigating. So, Leon, I'm sorry for jumping in, but I get excited about those several things. And so I wanted to take a moment.
No, you said you stole my thunder. I didn't have much thunder to give, so I appreciate having the experts dig in here. I'm curious about the use of AI. Do you have some speculation as to what that might look like in this area?
Yeah. So one thing that we've always talked about with the Wage Hour Division, it's one thing and we might talk. Sorry, Ariel, if I'm stealing some of your thunder now, but historically there have only been a few more than 1,000 investigators at Wage Hour Division. I think it got as high as about 1,400 at one point. I think it's down to about 800 now. And so how can 800 investigators actually fulfill an obligation to help to educate and enforce about the FLSA and the other laws that the Wage Hour Division has under its charge? And so we've always said, well, investigations happen in one of three ways: employee complaint, or a dartboard, or there's some sort of initiative that's going on. And so I think where AI would come in is in an analog to the initiatives that we've seen before. Some of the initiatives have been low wage earners, hospitality industry, stuff like that. But how do you select the employers who should be investigated in a rational way? And with big data and AI, presumably there would be a path to being able to do that. So that's just an example of what we've kind of surmised could happen.
So I want to maybe quickly, Brett, ask you to take a look at the next slide, and then I think there's a bunch we want to ask Ariel. But this is the org chart. As you can see, the administrator is vacant. I've been sort of in Washington for 20 plus years now, and that's just a common condition. That the vacant has probably been administrator of Wage and Hour longer than any other individual. And so let's talk about this chart. Who, position-wise, what matters about this chart? Who matters, and what do we want to watch as time goes on?
Yeah, but one of the things I've observed over the years is that you typically feel an investigation or an enforcement action at the local level. The investigator is prompted to do an investigation. Your local manager of your multi-unit operator gets a visit from an auditor. There's an information request, and then you're kind of off to the races. The place where we end up dealing with Washington, or the people who are above the local level, so that could be the district directors on up to the regional administrators on up to the administrator, in combination with the solicitor's office as well, is on those bigger issues, those issues where there's a question about the interpretation of law that is a problem or a challenge. Or the investigator, the local office, seems to be running more quickly than they should be, missing things. So you want to escalate on up. When there's an absence of the political people at the top, there's not as much opportunity to talk to them about how you interpret the law. That has other implications as well. For example, we have relied historically on administrators' opinion letters from the Wage Hour Division. We haven't seen opinion letters in quite some time, but there's no one at present who actually would have the authority to sign an administrator's opinion letter. And those are sub-regulatory proclamations of a sort about what the law means that we're dealing with. And so without that guidance from the top, without those people who advise and look at policy, it presents challenges. And I'll point this last thing out. There's always, anytime an administration changes, I hear from some business operators, hey, Trump is in office now, so we don't have to worry about Wage Hour, for example, or the Biden administration came into power, and so things are going to change immediately at the enforcement level. I would just encourage you to keep in mind that it's the political people who, under normal circumstances, are the ones who might shift in and out and have different views of the world. There is a whole mechanism that's beneath those political appointees who are long-term employees. They operate more like we do on a daily basis in terms of, what is my job looking like going forward? How do I ensure stability for myself, for my family, and all that kind of thing? And so it's always less likely that you're going to see a fast move at the local level because you've got more career folks than you do at the Washington, D.C. level. I'll just say, we're not necessarily in normal times. DOGE, and if it has an impact on the wage hour division and we start seeing more people leaving, we've seen some, but more people leaving, then we lose some of that stability as well. I'll shut up now.
No, thank you, Brett. No, that's always illuminating to hear what you have to say. Ariel, I want to turn to you now and perhaps look outside the enforcement sphere that Brett's been talking and talk a little in the litigation area, talk a little bit about legislation, regulation, and then maybe also after that we can talk a little bit about what the plaintiffs bar is up to and the way in which they're shaping things.
Sure. Well, I'll start by saying, and Brett touched on this when he talked about the EAP exemptions, is that it was a pretty busy 2024 year, kind of starting in the summer. We had a lot of employers coming to us with concern about if the salary thresholds would go into effect. And as Brett mentioned, a lot of our clients were not as concerned about the 880 or 844 per a week, but had a lot of kind of heart palpitations about what would go into effect in January 1st. And so at the end of the year, the rule was struck down, and then we, now have the appeals, which I see a question in the chat about whether or not we're surprised. I think Brett touched on the question by saying it was interesting. I'll say that I was surprised by the appeals rather. I didn't necessarily think that would happen, and it leaves us to where that will land, which I think is interesting. I don't think a lot of our clients or employers are that concerned about the 844 a week. So maybe we land there, or maybe we stay with the rule as it is, which is the 684 a week. But I think there was a lot of concerns by a lot of our clients, and then there was a lot of talk on the campaign trail, and there were other big rules and changes that happened at the end of the year too. For our hospitality clients, there was a lot of chatter about the 80-20-30 rule, which is the rule that went into effect during the Biden era. And if you are not a client in the hospitality industry, you might not have as much familiarity with this rule, but this was a rule that kind of regulated minimum wage based off of the job duties of a tipped worker. And the Biden rules essentially said that you couldn't spend more than 30 minutes doing non-tipped work. And there was litigation about it. Eventually, a Fifth Circuit case came out about it, and it not only struck down the Biden rule, but then started to put into question whether the 80-20 rule itself was even a relevant rule. And so we saw a lot of big changes on big wage hour cases. And all of that was happening kind of in the background, and we can turn to the next slide, of Trump kind of touching on overtime and taxes and tips in his campaign, which, as Leon kind of mentioned at the beginning, is not really a wage hour issue in and of itself or wage hour concern. It's more of an IRS kind of reporting, and effectively it has a flow down to employers as they've got to change their tipping and their overtime on tax perspectives or change their payroll systems, but it doesn't really change in theory a wage hour rule or wage hour practice. But it is interesting about the flow down. So I'm sure if you all kind of saw, there were big commercials about it, is no taxes on tips. So we saw a lot of those during kind of the October, November campaign era. And it's interesting because I think historically a lot of employees put a lot of stock in being considered exempt. A lot of employees, we hear from our clients a lot culturally, want to be classified as exempt. They see it as a more prestigious role or classification. But now you have this interesting juxtaposition where you might not have to pay if this rule comes into effect, or if there's kind of any federal rule, which there is proposed bills. But if it came into effect and there no longer was taxes on overtime, that now makes that overtime wage more attractive. And so maybe those employees that once wanted to be exempt look at their colleagues that are non-exempt and say, well, wait a second, they're actually making more than me because they're not paying overtime or not paying taxes rather. And the flow down from that is interesting because I think you're going to see potentially a cultural shift in people now wanting to be non-exempt, which might lead to more off the clock claims. People now saying, well, not only would I, assuming that the claims are within the tip or the no tax provision, but not only do I get to collect some money that I was working when I was misclassified as exempt, but I wouldn't have to pay taxes on those. And I haven't really seen it in practice yet, but I had a client last week reach out with an anonymous complaint that they got. Somebody who maybe had watched the TV during the campaign trail and didn't realize that potentially the rule was in effect, and says, hey, I want to be changed to non-exempt because I don't want to pay taxes anymore. The client understood that that wasn't the rule, but it was interesting because I had hypothesized that this would happen, but I actually hadn't seen it in practice yet. And then similarly, he campaigned that there were going to be no taxes on tips. There's a proposal, a bill in Congress right now called No Taxes on Tips. And I think for the same reason, that's going to become a more attractive rate. Oftentimes a lot of our clients in the hospitality industry have had a hard time, not only with recruiting in this industry, but also in the retention. And now that might become a more attractive role to people. I don't have to pay taxes on my tips. Now my wage might be worth more. I think also a flow down from that, outside of the IRS or the tax space, but gets back to the wage hour spaces, employers historically had a hard time tracking tips because often those are cash tips and employees are putting it in their pocket, or the reporting procedures don't really necessarily necessitate them reporting all of their tips beyond minimum wage. But now there's no real reason not to report all of your tips if this rule went through, because you wouldn't be taxed on them anyway. So I think that would kind of have an interesting effect. I also think there might be a flow down effect with that as well, is perhaps hourly wages might adjust from a labor economy standpoint because the value of that dollar is worth more. So you might see wages that might have been higher, maybe not getting increased at the same level because there might not be taxes on it. So there could be an adjustment. So I think that'll be interesting as well. And then smaller mumbles that I didn't see the commercials for these or the banners for these, but there was talk about doing overtime based on an 80-hour cycle as opposed to 40, which could be really interesting from a labor cost perspective as well, because oftentimes we've seen in some litigation is managers telling people, well, why don't you just move your overtime to the other hours? We don't subscribe to that here, but that would be interesting to see the ability to kind of have labor costs and employers kind of dictate maybe when the overtime is working if we're looking at it more of a 2-week cycle. So all of this is interesting. None of it's in effect, and I don't know that it will be in effect anytime soon, but it was something that was popular on the campaign trail. And I think it will have an interesting effect on how, wage hour cases kind of trickle down from that as well.
And Ariel, I have a question about this, although none of us are tax lawyers, but I'm assuming, in fact, I don't see a way for this to be anything other than a legislative measure. That Congress is going to have to decide to do this. And of course, the president will have to sign off on it. But that suggests to me a potentially long road to getting to this, as you've suggested.
I'll just point out real fast, and Ariel and I were talking about this a little bit, that there are state legislators who have proposed for state laws to be changed in this way, and it's possible that we'll see those go into effect before we would see anything at the federal level.
Yeah, I think that's a good point, Brett. I think that's on the next slide, Leon, and I was looking before we hopped on this call, Brett, and I saw quite a lot of states that have introduced overtime bills in the state arena, and many, I counted almost 15 states in the no taxes on tip arena. And so I think, Brett, as you know, we'll see a lot of legislation in the states to fill maybe some of those gaps that are kind of funneling from these ideas that Trump has introduced. Some of them, of course, were introduced prior to the campaign, but we will see kind of an uprise in this, and that makes it a little bit more tricky for us to all follow as wage hour attorneys, but might make it more attractive for some businesses to potentially recruit in certain states if that's a more attractive law to some employees.
Next slide.
So as we mentioned, there's a bunch of states that are doing this right now. New York just came out with a new bill yesterday on the overtime rule, and we're seeing some traction in Ohio on a no taxes on overtime rule, and we're seeing even more states, as I mentioned, on the no taxes on tips. And I don't know if you've been seeing some more others on kind of this gap filling recently, Brett, but I think it will be interesting how businesses will recruit and potentially maybe focus on certain states if this becomes an attractive rule to people.
Yeah, I'm happy to just offer a few thoughts, and it kind of relates to the next slide too. But let me just touch on the states that are identified here on this one. These are the states where we have seen a lot of activity around legislation, enforcement, litigation. They are states, and they're not always blue states. They are sometimes states that just have active legislatures that are looking at ways to protect their citizens. And so we have seen, Colorado is one place that comes up a lot. Oregon and Washington State are seeing a lot of activity, both at a state level and a local level. If we go to the next slide, the reason I think that's kind of pertinent to what we're talking about is, we've got a really active plaintiffs bar right now. I'll offer this comment just real quickly. These FLSA cases didn't begin to proliferate, as I mentioned before, until the early 2000s, after we saw a spike in California. For a long time, courts didn't really know what to do with them. I think now we're seeing courts for the most part, mature into how to manage FLSA cases. Similarly, the plaintiffs bar needed time to mature and to start realizing where in a saturated market in some states, they could still make money. And part of what they're doing is going to these other states that we just mentioned, where there are local or state laws that provide avenues. Like we hear about plaintiffs' lawyers in Washington State who were filing suit in Massachusetts, which has treble damages and some really quirky laws that are finally coming to light there, even though the plaintiffs' bar in Massachusetts hasn't really caught on to the idea of suing in their own backyard. We're seeing consortiums of law firms who are attacking certain industries or looking at certain states. So for example, I have to admit, I didn't know this, but in New Mexico, the statute of limitations on wage hour claims goes kind of like this. You have to file within a certain amount of time. Once you've filed timely, the statute of limitations goes all the way back to the beginning of the practice. And so it's not something we were paying attention to, but these plaintiffs' lawyers have figured that out now. And so they're filing suit in New Mexico, asserting state law claims along with their federal claims in order to take advantage of that. And we're seeing a lot of advertisements as well. And I'm sure that if you've been among the employers targeted by this, you know about the Facebook advertisements, the text messages, the constant social media interactions that these plaintiffs' lawyers are having. They're on the hunt. And I hate to say it, when wage hour is in the limelight, that's when employees start to sue. And I'll just mention too that, in times of bad economies, when we start seeing, and knock on wood, we won't see too many, but if we start seeing rifts, the reason that a lot of these wage hour claims arise is because an upset employee who is looking at a release agreement or otherwise has been let go, or they're just disgruntled, they go and they talk to an attorney about, hey, I feel like I've been treated unfairly. They never mention wage hour. Then the attorney says, well, you've been treated fairly, but tell me about your wages. Tell me about your overtime pay. Oh, you were never paid overtime. So that's kind of when we see things pick up. And I think that's kind of where we are right now. So we can go to the next slide, I think. And I'll just mention, Leon, I'm happy to keep running since I'm on a roll of sorts. Yeah. All right. So if we go to the next slide, from here, what will affect the landscape? We do have active judges who are willing to kind of break the mold of what's been going on. So in the Fifth Circuit, it's kind of wild to me. The Fifth Circuit Court of Appeals is taking a strict constructionist view of the FLSA, and the regulations that enforce it, which is leading to some results that are not favorable to the employer. And so There's a lot of activist judges going on. There are class and collective action standards that are changing. We're seeing courts more willing to deny class certification and collective action certification. We're seeing multi-jurisdictional attacks, and mass arbitration is still around. So we're still looking at that kind of thing. Ariel, what about in the government space?
Yeah, it's interesting that you say that, because if you had asked me 2 weeks ago, I would have said, oh, things have quieted down a lot. A lot of the initiatives that we saw last year, at least for me personally, were around child labor law initiatives. That's where the big matters came out of. And I think that's a bipartisan issue. So I still think we'll see a lot of focus on child labor law concerns. But I don't know that maybe we'll see as much focus on misclassification investigations or things of that nature. One interesting thing I saw a lot at the end of last year, and I've been seeing at the beginning of this year, is federal investigations, or things that started as federal investigations, were pushed back to the state. So I had several large federal investigations, and then they moved them back to the State Department of Labor agencies and attorney general offices to run them. And I don't know if that's necessarily impacted by federal funding, but I do think it's because they think that they're going to get done quicker. So I hadn't seen that a lot in the decade I've been doing Department of Labor investigations, but I've been seeing them pass them off to the state agencies more recently.
That's really interesting. And on the next slide, we've touched on a couple of these points, but we talked about AI and its potential use in the wage hour space. We had seen under the first Trump administration, this paid program. Going back years, we used to see there used to be kind of a program that you could participate in as an employer, where you would go to the wage hour division, ask them to oversee a self audit. You would go off as the employer and do a review of practices, and then come back to the wage hour division and say, hey, this is what we found. They would look it over, and if they agreed that you'd done a thorough enough job, they'd oversee the payment of back wages and the use of releases to get enforceable releases from employees in exchange for those wages. They stopped doing that, but then under the first Trump administration, they had this paid program that has gone away. We might see something like that come back, and it wouldn't be a bad thing. Leon, anything else you want to touch on that stuff?
No, I think as far as I can see, I think we've covered it. I think where I would like to move, we've got about 8 minutes to go, is just what employers need to be doing now. And I think I'd put, both of you work a lot with employers in these areas, so I'd love to hear what you have to say about that.
Yeah, it's a good question, and it's hard in uncertain times when you don't really know what's coming to know what to do about it. And so as a firm, we pay attention to the EOs, we pay attention to the regulatory action, we pay attention to what's at the sub-regulatory action with opinion letters, with pronouncements from the agencies and that kind of thing. And we're trying to stay on top of all that. And so we've got the ability to help out if there's a in-house counsel or an HR or payroll professional at a business. We've got resources that we can use for that. But the questions come up like, how am I supposed to stay on top of this? And if there are issues that I'm aware of, what do I do about them? And it's not the time to put your head in the sand. It's a time to be considering, what is it that we're doing as a matter of practice locally and then system-wide that might create vulnerabilities. These wage hour assessments that we help with sometimes look at exemptions, look at pay practices. We look at masses of payroll records and time records to see if there's any indicia that there's been off the clock work, kind of forensically looking at all that stuff. You don't have to have outside counsel to do a lot of these reviews. One thing that I like to harp on, might be the wrong word, like to reiterate firmly, is that if I'm defending a big case and wage hour practices are at issue, I want my 30B6 representative witness or my person with most knowledge to be able to sit down and in response to the question, what have you done to comply with the law, to have an explanation of all of those things that have been done. And so raising wage hour issues regularly and being able to say that we've trained on them, we talk about them, we focus on them on the right reasons or for the right reasons, that's all going to matter. And then going back to that point that we touched on a little bit ago, A happy employee is one who's less likely to file a claim. And I'm not suggesting that you need to ensure that all of your employees are happy, but employee relations matter. We're seeing more union activity these days. Generationally, unions are more accepted, and there is a greater focus on matters that could percolate into, again, that outreach to an attorney to say, I don't like the way I've been treated. And the attorney says, tell me how you've been paid, and that kind of thing. Ariel, I don't know if you have additional thoughts beyond those.
Yeah, I would echo a lot of the things you said. One thing that I've noticed kind of recently as we arguably get closer to what some people believe might be a recession is that people have started to focus on saving and how much money they have. And I've noticed more recently in my practice that people are looking at their paychecks with a little bit more of a discerning eye these days. So in the last few kind of weeks, months, I've noticed a lot more questions about pay wage statements, how overtime is calculated, regular rate questions, because now people are starting to make sure that they want to make sure they're getting every dollar that they work and that their pay is calculated correctly. So I think as you note, Brett, now's the time really, and it should always be the time, but now's really the time for our clients and companies to really have a deep understanding of their wage hour policies and practices and be able to answer those questions, because I am seeing those questions more frequently. How's my pay calculated? Because people want to make sure that they're getting paid correctly so that they maybe can pay for the increase in costs and the things that are kind of happening around us in the world.
I absolutely love that point, Ariel, and I'll just put a little bit of a point on top of it. I have these conversations with our clients sometimes. If I can't understand how my pay is calculated by looking at the very basic documents that I get, I'm more likely to file suit. And so think about that. Look at the pay records that you have, look at the paycheck stubs, look at your pay policies, look at your commission plans if you have those, make sure that you understand them, because if you don't, certainly your employees won't.
So let me take a moment. We're approaching the top of the hour to share the CLE code, and that code is S as in Seyfarth, 3723. Once again, SS 3723. And you'll see that there is a QR code on the screen that you can scan to note your attendance digitally. Ariel, I'll start with you first. Any last words before we wrap up for the afternoon?
There's a lot of obviously government action going on, and we're here to help in the extent that wage hour concerns come up. We haven't necessarily seen major DOGE efforts or anything around wage and hour, but I do think in the next year or so, as we discussed, Leon, through congressional efforts, we might see that. And so certainly, as Brett also added, keeping a watchful eye on the changes of the EO and things like that, and certainly reach out to us because we are keeping a watchful eye out on those as well.
And Brett?
Last thing I'll say, there were a couple questions about the FLSA's EAP exemption salary level litigation in Texas, and I realized that we didn't really close the loop on that. Like, what do we think is going to happen? Were we surprised by it? Yes, we were surprised that there was an appeal, but not as much as you could have been, because if history is a preview of the future, we saw that happen previously back in 2016. DOL took appeal from the order that invalidated the rules. And then Trump came into office, the administration changed, impacted what was going on, and that thing just kind of petered out. And so I wouldn't be surprised to see this appeal just kind of peter out. But we got to watch it. So that's all I've got, Leon.
Okay, and of course, being the moderator and not necessarily a wage and hour expert, although every once in a while I fake it, would say that I think the next 3 or 4 months are gonna be very critical as the administration begins to staff up both in the White House and within the Department of Labor, specifically in connection with this area. This is the kind of area that could very much be driven by somebody nobody knows in the White House, or somebody in the position of the wage and hour administrator who's relatively new to Washington. And all the players and characters we're looking at so far may or may not end up mattering. So it is a time to be alert, to stay in touch with us in particular. We'll certainly be continuing to put out blogs about this. We'll certainly revisit this in webinars to come, because this is going to be a time of continuing change in this area. And with that, I thank everybody for joining us. Brett and Ariel, thank you. I actually learned a lot from you, so I appreciate having been able to spend this hour with you.
Thank you, Leon.
Thanks, everyone.